In 1868, the Crow tribe of Indians agreed to cede to the United States 30 million acres of its aboriginal land and move to a reservation. In exchange for ceding its land, the tribe expressly reserved the right to hunt on that ceded land.
Hey everybody, welcome back. Today we're going to be talking about Herrera v. Wyoming, a case that involves Indian tribe treaties, elk, and even a little bit of states' rights. Before we hop into the actual discussion of the case, I just wanted to say thanks to all of you. By the time this video is actually posting up, I've doubled my channel size to 20 whole subscribers, and I've hit my first 1,000 views. So thanks to all of you that have subbed and that watch. I really appreciate it. And with that, let's go ahead and hop into the facts of Herrera v. Wyoming. A little bit of history. So as you heard in the Supreme Court argument at the top of the video, the Crow tribe entered into a treaty with the United States government in 1868 in Laramie, in what is now Wyoming. They, at the time, ceded about 30 million acres of their territory to the United States and agreed to move onto a reservation. This area bordered what is now the split between Montana and Wyoming. In exchange for that, they were promised the ability to hunt on unoccupied land of the United States, so long as there was game and there was peace between the Indian tribe and the whites. You can't see my finger air quotes, but they're there. At the time that this treaty was signed, Wyoming itself was actually still a territory. It wasn't until 1889 that they began the Constitutional Convention process to become a state, and they were granted statehood on July 10th of 1890. Now, complete side note, but fun fact, Wyoming was actually the first jurisdiction, the first territory that allowed women to vote. And women gained the franchise in Wyoming in 1869. It's completely unrelated to this case, but an interesting fact nonetheless. If we jump about 150 years into the future, a man named Clayvin Herrera, who was a member of the Crow tribe, as well as other members of the tribe, were out hunting elk to feed their family. While they did start the hunt out on Crow territory in Montana, they actually crossed the reservation line and moved into Wyoming and entered the Bighorn National Forest. It was in the forest that they ended up actually killing an elk. They then took the elk from Wyoming and transported it back to Montana. This perturbed Wyoming, and they charged this man with hunting without a license off-season. He actually put forward a treaty argument saying, I have complete right to do this. Bighorn National Forest is unoccupied. The treaty says I'm allowed to hunt here. What are you doing? The court ignored that argument and said, you're not allowed to raise that issue with us. They then convicted him on that charge. They suspended his hunting license for 3 years. He got a suspended jail sentence and an $8,000 fine. And as usual through the various appeals, we then end up at the Supreme Court. In this particular instance, the court had 2 cases that it needed to look at to determine which of them controlled in this instance. The state of Wyoming said that a case called Racehorse should control, and that particular case did deal with hunting rights guaranteed in a treaty with the Shoshone and the Bannock tribes, and the terms of that treaty were exactly the same as that between the United States and the Crow. In the case of the Racehorse decision, the court at that time actually said that the treaty between the Shoshone, the Bannock, and the United States was extinguished when the state of Wyoming became a state, as opposed to a territory. And they said this for 2 particular reasons. First, they said that new states come into the Union on equal footing, and so if there was a limitation on the state that wasn't in place on all of the others, in this instance, a treaty with a sovereign nation, the particular tribes, it puts them at a disadvantage, Wyoming itself, in comparison to other states. And second, the most ridiculous part, they said that there was no evidence in the treaty itself that the parties intended for it to be infinite and was instead of only a temporary and precarious privilege. Mr. Herrera, instead, argued that another case called Mille Lacs should control, and in that instance, the court actually agreed with him. That particular case dealt with another hunting treaty, this one from 1837, between the United States and the Chippewa Indians, who had the ability to hunt on a particular parcel of land at the pleasure of the president. In the Mille Lacs case, however, the court actually found that the treaty survived Minnesota itself becoming a state. Just like the racehorse case, the Mille Lacs court took a look at the issue in a two-pronged fashion. First, the court determined that states were in fact able to reconcile basic things like sovereignty over natural resources with other jurisdictions and keeping a balance between the states. So there was absolutely no reason that a state gaining statehood and being on equal footing with the existing states would reduce its sovereignty in any way. That balance wasn't thrown off by the existence of a treaty with the Chippewa. Second, that court looked and said that the government, the United States government, had to clearly express any intention that it had to try and abrogate the Indian tribes' rights under the treaty. In short, they had to explicitly say when they made the treaty that it's temporary in nature, that it can be limited in this way, that it can be terminated in that way. Simply assuming that that was understood is not good enough. In the case of the Mille Lacs Treaty, they actually did set out the way in which the treaty could be terminated, the right to hunt could be terminated, and that was important for the analysis. Now, the court in this case basically came down and said that Mille Lacs, which came after racehorse, in effect made it impossible to harmonize the two. And while Mille Lacs did not actually wholly overrule racehorse, it basically neutered it to the point that the court said it had no vitality left in the racehorse decision. Once the court had come to that decision, this case was actually quite easy for them to decide. They looked at those same two basic prongs that the other cases looked to. Here, Wyoming statehood at the time said nothing in the authorizing documents about shutting down the treaty rights of the Crow tribe in the 1868 Laramie Treaty. There was also nothing in the treaty itself that showed Congress had any intention of destroying the right or preventing it remaining in force even after Wyoming would become a state. Congress didn't say anything about terminating the treaty in relation to Wyoming's statehood or other jurisdictional status. And in fact, the treaty itself doesn't have any language in it that contemplates termination at the point that a state would be created. It did, however, lay out 4 particular instances, much like the Mille Lacs Treaty did, in which termination would occur. When the lands were no longer unoccupied, when the lands were no longer belonging to the United States, when there was no longer game to be found on the land, or when the tribe and the non-Indians are no longer at peace on the borders of the hunting district. None of those things had anything to do with Wyoming being a territory or a state. And because absolutely nothing in this regard pointed to the express limitation as to the length of this treaty right, the court said, that's not good enough. Wyoming becoming a state does not destroy the treaty. The court then moved into Wyoming's second argument, that even were the treaty to survive Wyoming becoming a state, the national park is not unoccupied, largely because it was specifically set aside as a national park to be used by the public and federal land. And because it's federal land, it is not unoccupied. The court, again, not impressed. Side note number 2, in contract law, you have a concept called the meeting of the minds. And where that meeting doesn't occur, it can often undermine a contract. Treaty just happens to be a large-scale, national-level contract. And that meeting of the minds element plays into this issue. The court here said that regarding the issue of occupation for purposes of the treaty, the Crow tribe would have understood occupied to have meant some kind of residence or settlement, a group of people being there, not simple ownership or designation of a protected area. When the court looked at the documents and the treaty itself surrounding this issue, unoccupied in almost every instance seemed to denote an area free of residence or settlement by non-Indians. The court even took an extra step, and they said that based on the language in the proclamation issued by the President making Bighorn a national park, and taking into consideration the unoccupied portion of the treaty and the surrounding meaning, the designation of Bighorn as a national park would actually seem to make it more unoccupied, as in more available to the Crow tribe for hunting, not less. Wyoming at the time pointed to mining and logging communities that were in the area in 1897, trying to make the point that they were occupied lands. But the court said no, that's insufficient, because as the Crow tribe would have understood occupied to mean at the time the treaty was set, the temporary mining and logging communities would not have met that definition. They weren't settlements. They weren't groups of people living somewhere permanently. They were encampments, temporary work-related housing areas. And so, having looked at those two prongs, the court came to the determination that the Crow tribe's right to hunt on unoccupied land, including Bighorn, survived Wyoming's statehood, and that land was not made occupied when it was set aside as a natural reserve, though it didn't go so far as to say it was unoccupied land, because this court sent the case back down for remand and additional review at the lower court level. And so with that, this court upheld a plain language reading of a tribal treaty from 1868, and a man was able to go hunting with his friends to feed his family on unoccupied land. That is Herrera v. Wyoming. I hope you enjoyed this particular video. As always, until we meet again, I hope you're well.